What gets really confusing is not far down the statute from there. On my printed copy, it's on the same page. There's then just a subsection K, which is about modification. And we're actually talking about both of those Ks. So an issue that Judge Williford initially raised was, I'm going to read you the statutory language. It says, the court may order or the jury may find by special interrogatory a deviation from the presumptive amount of child support when special circumstances make the presumptive amount of child support excessive or inadequate due to extended parenting time as set forth in the order of visitation, the child residing with both parents equally, or visitation rights not being utilized. Do you want me to go into why that's a problem, Judge Williford, or do you want to expound?
Well, I thought it was a problem because if we did not have parenting time built into the table and it was just, it assumed an intact family, then how could we then say, Judge, you can modify or deviate if the person exercises more parenting time than they were supposed to exercise or less parenting time than they were ordered? Because if it assumes no parenting time to begin with, then your child support was based on, let's just say mom had the children 365 days a year and dad didn't have any. If it was based on that, then what difference does it make if dad exercises more time or less time? Because he's already paying based on, I don't exercise any time. So that was confusing to me, is how it could be that parenting time was not built in, and yet we're going to be able to modify and cause dad to pay more or less depending on the parenting time. That was what was confusing to me. And is that how that reads, or did I misunderstand it?
I think that's how it reads. Like, what I hear you saying is the language about inadequate. It would never be inadequate, because if there's no parenting time deviation given, the custodial parent is sort of getting the full amount of the BCSO. She's being allocated all of that money. But now with our adjustment, or the old parenting time deviation, there should have been some moving of that money over to be retained by the non-custodial parent. So what you're saying to me is there should only ever be a downward deviation to reduce the amount of child support if there's parenting time by the non-custodial. There should never be a raising of child support because that person's already getting, if there's no deviation or no adjustment, that person's already getting the full amount of child support.
Yeah, how can we deviate and say, all right, since you're not exercising your parenting time, we're going to make you pay more child support, when we were never giving them credit for the parenting time to begin with? So I think maybe when we talked about this before, you read it as if they had been given a deviation, then they need to lose their deviation.
I haven't gotten there yet. That's the other K. So why don't we take a second and walk over to the other K? So under modification, few subsections down, it's talking about when a modification may be brought. And it says, so K2 says no petition to modify child support may be filed by either parent within a 2-year period from the date of the final order on the previous petition to modify by that same parent, except when, and A says a non-custodial parent has failed to exercise the court-ordered visitation. Or B, a non-custodial parent has exercised a greater amount of visitation than was provided in the court order. So for me, subsection A, the non-custodial parent has failed to exercise the court-ordered visitation. That could be a rescinding of a parenting time deviation that was previously granted. And it doesn't have to necessarily be these like ill-intended.
But it doesn't say that. It doesn't say that.
Right, it does
It
not
makes
say
it
that.
sound like you could modify it if they didn't exercise their court-ordered parenting time. It doesn't say, and they were giving a deviation for their parenting time.
That's so funny. That's one of the things I think should have been added. I said, if a PTD, if a deviation was granted, then all you would be doing is rescinding the parenting time deviation, because this could come up in a natural way. It's not nefarious. It's not somebody saying they were going to do parenting time and they're not doing it. It could be simply somebody moved so much so that it's really affected their ability to have that amount of parenting time. So it's just grounds for the modification. But yet again, I think there needs to be clarity. And I wish Pat were on the line, because it was my understanding that this was modified during her tenure in this role. And it was meant to be punitive.
But I don't understand how it could be proper to say, hey, if you don't exercise the time you were granted, we're going to punish you, if it was meant to be punitive, right? When you're already being punished, if that's the word, to the full extent, because you're already paying based on, I get no parenting time. But again, I think the fact that we've hopefully fixed or corrected the parenting time issue, assuming the full commission will go with what we're recommending and there will be a parenting time adjustment moving forward, that may help solve a lot of these problems. But I do think that we have to keep our eye on that part of the statute where it talks about when modifications may be brought within a 2-year period, if it's related to, if there's a misunderstanding of how this table works. And I fully believe that there has been a misunderstanding, because when I spoke at the family law seminar, and again at the staff attorney training, just this year, hands raised, how many people believe parenting time is built into the table, and people swear I was trained on it. I had one person, I think that I told you, said I was a trainer. I trained the trainers and I told them that this is how it worked. So Judge, you're wrong. Standard parenting time is built in. And I said, no, it's not. So, I believe that this language was either constructed with that misunderstanding, or that the language is just wrong, because I don't know how you can ask somebody to modify their child support upwards to more than what it would be if you never had the children in your custody at all.
Right. Well, it was it's my understanding it was a change a few years ago when Pat was here. So I don't want to speak on her behalf, but she will, I'll let her talk at the next meeting.
Yeah.
But she will say it bubbled up from Superior Court judges. So
yeah, well, again, it might have been Superior Court judges who didn't understand that parenting time wasn't built in.
Right.
Because that misnomer and that misconception, that folklore out there, I think has caused a lot of problems and continues to cause problems. And I don't know, other than doing what we've done in putting forth this, information, I don't know how we can train that. I mean, it is so ingrained in our state that I don't know how we can correct it. Send out information that says, look, there's a problem. We've discovered there's a problem. We've discovered that family law practitioners, judges, all of these people believe this is true and it's not. Literally, it seems to me there needs to be like a mass, communication of that through every channel that we could possibly get it out there, because it's just unbelievable to me that so many people, including judges, believe that. And I've had conversations with the family law president. The president of the family law bar believed it, with other judges who believe it, with the Family Law Institute members who believed it, with the staff attorneys who believe it. So I don't know what we need to do to get some mass communication out that this is not the case. And I think part of the solving of this problem, the parenting time adjustment that we're recommending, when we roll that out, we need to make sure that people understand, here's the problem. People believe this. We've now learned that, a large majority of practitioners, judges, believe this folklore that was not true. And this is how we're fixing it, because they're going to say, why are we fixing something when it was already built in? And so we've got to first educate them that it was not built in, and that's why we're fixing it, and this is how we're fixing it. And so to me, part of the question needs to be, how do we roll this information out? Like we rolled out this survey, for instance, to all these different people. How do we get this information out that we've discovered there's a folklore out there and we need to correct it, But let's
concur. This is Judge Colbert. I concur. I wasn't reading or considering that it was built in for no parenting time. And I'm fairly new, 2.5 years, almost 3 years on the bench. And I did not realize that.
Well, Judge Colbert, I can tell you that as a practitioner in family law for 20 years, I have told many, many, many clients who complained about their child support and, why do I have to pay in the summer? And why do I have to pay when I have them, this? And I would say to them, because it's built in. I would tell them it's built in. It assumes that you're getting this time. And I didn't just make that up. I was trained that somewhere when this all came out. And it's been clear to me that I didn't just dream that, because I have talked to so many other people who say the same thing. So I believe at some point when Schedule C was supposed to be part of it, or when it was first drafted, that was discussed, and that somehow became ingrained in us, and then it actually didn't pass the way it was drafted. So it became this problem. And, here we are almost 20 years later trying to correct the problem, but it's hard when it's ingrained in people that that's the truth. Listen, I've had arguments with people who just swore me up and down that I was wrong and that I had misunderstood it and I didn't know what I was talking about. And, I can say I'm the vice chair of the Georgia Child Support Commission. I know what I'm talking about. And they'll say, no, you don't, So trying to get that information out there and have people actually believe that has been, like a mission for me since I learned that I was wrong about it. And trying to communicate that to everybody that I can communicate that to. But Noelle, let's push E and F to the next agenda, and we will take up those topics. Shohana, you have your hand up.
Yes, Judge. I was just going to tell you, I offered to do a lunch and learn on parenting time deviations for our circuit. That's actually going to be this Friday. So I wanted to go back and get that question answered. And so I started looking at the 2005 legislation that was adopted, and then the 2006. And in the 2005 legislation, you have the 80-day standard visitation built right into the code. And then with the April 2006 legislative session, that was all replaced before it became effective. And it was yanked out, but language was left in saying extended parenting time. And that's been in there since the very beginning. So, you look back at the implementation guide that the staff put out, Jill Radwin and others, and it has to address the fact that the code says extended parenting time. But if it had never said extended, I think we wouldn't have run into as much of an issue. But when you see the word extended and know that that's part of the statute, you still have to think, okay, what's extended? But then, yes, if you think that this extended means above the 80-day, it actually didn't kick in a parenting time deviation until it reached 100 days. And so I did put together, I've got a little PowerPoint, and I'm not suggesting that anybody would ever want to use it, but if anybody needs that history, Elaine had already asked if I would send her that or send her some information, and I'm glad to share that after I do this and get it final. And then people can make their own assessments. I'm sure there's people who were around then, but it's hard to remember what happened back in 2005, 2006. But I think you're absolutely right. I think that from my reading of the differences in the code, I think that's what happened. But I think judges still today are going to be concerned about the fact that it says extended. So what do you define extended as, or special circumstances? But that might at least clarify for people what the issue was way back when and why people believed it was built in, even though statute itself says it's based on intact households.
What I would love to do is the Superior Court judges have a winter seminar and a summer seminar every year. And what I would love to do is get that information and see if I can get in touch with whoever's in charge of those seminars and get that information out there. Whether I could speak at the seminar or whether or not it could just be included in the materials, but that would at least start to make sure that Superior Court judges are educated about it. I could also get it to the judges who teach new judges orientation. You know, that's, I believe, offered at least once a year, if not more, in December of each year, to any judge that was either elected or appointed during that year. And so it could be put in that NJO material and, you know, taught there. But I just feel like that we need to start thinking about how do we recognize that there's a problem and that people believe this. How do we start really educating folks that that is not the case, you know, and really brainstorming where all we can do it. And I certainly appreciate that you're doing the lunch and learn, but that's going to reach, you know, this many people, and we've got all these people to reach. So I think it behooves all of us to really brainstorm on the members of the commission, the members of the subcommittee, who all we can reach, who all we can educate, but then trying to think of, you know, the bigger picture. Noelle?
Yeah, I completely agree. And communications is always, you know, the not many people just naturally stumble upon the Child Support Commission website, so we can't rely on that. But I have to say it needs to be a concerted, like multi-prong approach. For instance, Elaine and I are going to, and LaTanya are going to speaking at the ADR Institute. So we can talk about it there. That's in November. That'll get mediators in the fold. We can talk about it again at the family law section, like you said, to judges, absolutely, at their conferences. And then also like the staff attorney training, like not only the judges, but the staff attorney training that happened in August, that's so mission critical. So all of those people, if different flanks of us are targeting those different populations, we can then get, I think, to a critical mass of understanding, where then they'll be training, helping spread our message too, that nope, that's folklore, this is why they're changing it, et cetera, et cetera. I completely agree with what you and Johanna were saying, and I've done the research myself. A lot of this folklore came out of that last minute change back in 2005, 06, 07, when the famous Schedule C was removed, and it's really done a lot of damage, and we're still feeling its effects now. But you know, I'm hopeful. I think we can turn it around. I think, to your point, Judge Wilford, acknowledging that there is this problem and there is this misunderstanding and folklore out there, and we just got to get it corrected. So there's an entirely new category of thing, and in fact, somebody brought it up in the chat, and it is on our major to-do list with drafting the new legislation. But food for thought is, if it gets adopted, right? If our proposed parenting time adjustment is approved by the full commission and then finally passed into law by the General Assembly, would that alone be grounds for deviation? Or has anybody thought about being clear on, on that being a grounds to modify child support. Not expressed in the statute, but like,
I'm not sure I understood your question.
like, is there going to be a rush to modify as soon as the parenting time adjustment is, all those people who never got a deviation, and it's like, what? I'll now get this much credit. And so Katie would probably be, she's like raising her hands. Thoughts?
Sorry, everyone, for being so late. Court got a little crazy. So I've been thinking about that, Noelle, a good bit. As I recall, we've made other changes to the statute since our current version went into effect, where we put parameters in that it had to be a certain percentage of change before, if that's the only reason for the change, before it would warrant a modification, essentially to stay off a flood of modifications because of the change in statute. I mean, I think we would have to be, if we were going to entertain something like that, which I think we should at least discuss, I do think we would need to be very clear that, whatever threshold we put in there, the threshold would only apply if that's the only reason for the modification. And maybe we even put in some sort of sunset provision on it. I mean, because I candidly, I can make a case for the idea that to prevent the modifications is to leave many Georgia parents in a position of, we're fixing a problem we know is a problem, and then we would potentially be telling people, yeah, you got screwed, and we know you got screwed, and we're fixing it for the future, but not for you. And that doesn't feel right to me either. So on the other hand, we don't need to overwhelm our already overworked and underpaid superior court staff. I don't know. So I'm in favor of, at a minimum, discussing it. And but I also would be in favor of some sort of, tempered approach, or, some sort of sunset provision on it, or I don't know, somehow acknowledging that we don't want to make this change, but then bar the door to people who need the change and should have gotten the benefit of a parenting time deviation. And just because they happen to have established their child support, whether it was through divorce or some sort of legitimation action, or, something prior to, the 2024 legislative session. So.
Well, that's usually, this is Holly, legislative counsel. That's usually how it works for statutes, especially criminal statutes. And we don't want to have any sort of retroactive whatever going on. We do provide, or we would insert some language. This applies to all orders entered after certain amount or whatever threshold the commission sees fit. That could definitely be drafted in the legislation for that transition.
This is Judge Colbert, I guess, and I wonder, would there be anything, I don't know, that legally judges would not be precluded from considering that with respect to contempts as to the willfulness of someone's failure to pay, if in fact they were ordered to pay an amount that did not consider the fact that they were spending significant time parenting their children, and therefore could not afford to pay both the ordered child support amount while also caring for their children while they were in their care during their parenting time. I don't know that that's something that needs to be put in the statute, but I just know for me, when hearing cases, I'm always looking for willfulness. It may not take care of the arrearage, but if the person isn't going to be held, sanctioned for not paying it, it almost has the same impact, because I think I will have a hard time going forward holding someone in contempt when in fact they could not pay, the amount, and they've been exercising significant parenting time with their children, which we all know, those of us who are parents, they're expensive when they're in your care, whether it's a weekend, a week, a summer, what have you. But
Well,
I guess my question is, do we need to put something like that? Or I think it's just discretionary upon judges, when we don't hear evidence of willfulness, and if we're all educated to know that presumptive amount considered no parenting, it was built in, and we have a parent who's been spending time with their children, that's just food for thought.
I remember when I've been around long enough to remember when this statute became the law in the state. And it, you know, it changed child support for a lot of people, but it was clear in the statute that you couldn't, just because we had a new income shared formula and we were no longer using the percentages, that in and of itself was not reason enough to come in and file a modification. And I mean, it did change child support substantially for a lot of people. This new law did, but it was just recognized that there's no way that DCSS and every person who paid or received child support in Georgia could not go flood the clerk's office with modification petitions, or the court system would just shut down. It may not be fair, but it was a reality. And I'd be interested in looking back at that language and how it was worded, but there was something that, had to happen above and beyond just the fact that the statute had changed in order for you to be able to, to modify. So I feel certain that we're going to have to look at something like that. Otherwise,
And it's in the statute, Your Honor.
Yeah,
It's actually, it's in the modification section, right under that other language that we were talking about earlier about when you can modify for, failing to exercise parenting time, or too much or too little, all that jazz. It's right under it. So it would be interesting, and for us to all look at that and consider it. I can throw the site in the chat.
yeah,
Is it a 25% threshold, Noelle?
If there's a difference of at least 15%, but less than 30% between a new award and a child support award. God, you see, this is always worded. I'm like, what does this mean? Hold on, I'm trying to come up with an answer, Katie. And that 25 is listed below. Let me just read it, I guess. It's pretty long though, but it says if there's a difference of at least 15%, but less than 30% between a new award and a Georgia child support order entered prior to 2007, the court may, at its discretion, phase in the new child support award over a period of up to 1 year, with the phasing in being largely evenly distributed, with at least an initial immediate adjustment of not less than 25% of the difference, and at least one intermediate adjustment prior to the final child support adjustment at the end of the phase out period. So I'm not even sure what that means.
It doesn't actually bar anything. It doesn't bar the modification. It just says how it'd be phased in.
Mm-hmm.
Yeah.
And Holly,
That's not what I was referring to, though.
Okay.
I was referring to something where when it first came out, and I may be wrong, but I thought there was something that said just the change in the statute alone would not be enough to go in and file a modification, that you had to have, there had to be another reason to modify, not just the change in the statute. That's about if there's going to be a difference, how you're going to phase in the difference. But I was specifically referring to something that said,
got it.
The change in the statute alone is not a cause enough to allow, to be a substantial change in circumstances or whatever it is to get a modification. Ryan?
Would it be under that language of the 3-year cycle and having to provide what is it, a significant change in circumstances? I don't know if that's in 19.6.15. I'm pretty sure it's in 19.11.12.
Yeah, and for you, it's 3. For DCSS, it's 3 years. For private cases, it's 2 years, and it is directly in the statute. It says, no specific time unless there's a substantial change, and then not greater than every 2 years filed by the same parents. And there still has to be those other things going on. So, but I will look if there's anything else in the statute about what you're talking about, Judge Wilford.
Okay. But that is something that we need to put on our agenda is, do we need to put, consider language in the statute about, modifications based on these adjustments that we're talking about that we've, you know, assuming they pass, low income parenting time adjustments, whether or not that's going to trigger the right to go in and seek a modification.